What happens to the special needs trust at the death of the beneficiary? We will discuss the estate recovery procedure used when a beneficiary passes away, the determination of payback to the state, the no distribution rule, and why WISPAC requires funeral and burial plans to be prepaid for first-party trusts. First, the estate recovery procedure. The following procedure is used at the death of the beneficiary. Upon notice of the death, trust subaccount is frozen and no distributions can be made. A death certificate should be provided to the trustee. The trustee then submits a letter to estate recovery with the name of the beneficiary, the account number, the Social Security number, date of death, and assets as of date of death. A typical turnaround time for a response from the Department of Health Services is 30 to 90 days. DHS sends a letter with the payback amount to the trustee. To terminate the trust subaccount, assure that the death certificate has been received by the trustee. We determine whether the trust will be subject to payback with remaining funds going to the heirs or if the trust will be fully retained. Once all the paperwork, the death certificate, the DHS letter, and the informational returns, the W-9, are in, the trustee will terminate the trust, which will include the date of death and the fair market value of the assets. How payback is determined. A first-party trust may be subject to paying the state back for medical assistance services the person with a disability received after the age of 55. We say may because it depends on the amount of the balance, if any, at death. We call it the all or nothing rule. If there is enough balance in the trust account to pay back the state in full for MA services received, then the state is paid back. MA services that may be recovered through estate recovery are institutional medical assistance, nursing home services, hospital services as an institutionalized person, if hospitalized 30 days or more. For MA recipients 65 years and over, home health services, personal care services, home and community-based waiver services, all long-term care services, other waiver services, and if the beneficiary was a participant in the Wisconsin Chronic Disease Program. However, if the funds at death are insufficient to pay the state back in full, then the funds go into the WISPAC Charity Fund to be used directly to benefit other trust beneficiaries. Our charity funds initiatives like advocacy, emergencies, non-covered MA benefits, transportation, assisted devices, vocational services, financial literacy, and more. People often ask, can my family inherit remaining funds? They can, but this is unlikely. Only after the state is paid in full does any balance go to the remainder beneficiaries as designated by the primary beneficiary. No distributions at death rule. By law, a first-party special needs trust cannot pay for anything once the beneficiary passes away. The types of expenses allowed from a first-party trust after the death of the beneficiary are very limited trust administration expenses. Specifically, they are taxes due from the trust to the state or federal government at death, and reasonable fees for the administration of the trust estate, such as an accounting of the trust to a court, completing and filing documents, or other required actions associated with termination and wrapping up the trust. The list of allowable distributions post-death is small. Not included are expenses of the beneficiary, such as taxes due from the estate of the beneficiary, other than those arising from the inclusion of the trust in the estate, inheritance taxes due for residual beneficiaries, payment of debts owed to third parties, funeral expenses, and payments to residual beneficiaries. This does not mean that these expenses are ultimately not possible to pay from a first-party special needs trust. However, unless the request is one of the listed expenses I mentioned earlier, that is taxes and fees, it will be impossible for your trust to pay for anything else until the state has been fully paid back for medical assistance received by the beneficiary. Funeral planning. Given this information, it is prudent to plan your funeral arrangements in advance, during life. Your trust can pay for the arrangements. Funeral and burial expenses, such as an irrevocable life insurance policy, are an exempt asset, and they are not countable towards your public benefits. The good news is that this can be done very easily and in a way that does not jeopardize the beneficiary's public benefits. The general suggestion for a beneficiary on means-tested public benefits is to choose a funeral home and specifically arrange for services that are exempt for Medicaid and/or SSI purposes. Funeral homes usually have extensive experience with such situations and will know exactly what to do. However, if you have questions, you are more than welcome to call either WISPAC or your attorney. In conclusion, please remember there is no state payback for a third-party trust in WISPAC Trust 2. After a beneficiary's death, any funds left in the subaccount will be distributed according to the wishes of the trust creator in the contribution agreement. If you have any questions whatsoever, please feel free to contact WISPAC at 608-268-6006 and speak to any one of our staff, our trust advisor, our beneficiary specialist, or our executive director. Thank you very much.